mixed messages in ways that left everyone unhappy in one way or another. One thing that has become crystal clear this term is that, for good or ill, the court now truly deserves its moniker as the Roberts Court. And that's due in large part to perhaps the single most significant event of the term, the October 6 confirmation of the court's newest Associate Justice, Brett Kavanaugh. Justice Kavanaugh has already begun to chart a course of principled adherence to the rule of law and the text and structure of the Constitution. The nation owes President Trump and the 50 United States senators who voted to confirm him an ongoing debt of gratitude for this superb appointment. Of course, not everyone acknowledges that debt with enthusiasm. In March of this year, for example, would-be President Kamala Harris expressed concern that, quote, "We are on the verge of a crisis of confidence in the Supreme Court." Apparently, things got even worse very quickly because 2 months later she said, quote, "You and I are experiencing a crisis of confidence in the Supreme Court." And that was even before the Chief Justice announced his opinion in the Census case. In fairness, other politicians have offered more thoughtful commentary. For example, noted Supreme Court analyst Alexandria Ocasio-Cortez recently observed that the Supreme Court, and I quote, "has gotten things horrifyingly wrong in the past." A sentiment that I'm sure we all share, although we might disagree with her on some of the details. Now, ironically, her solution to this problem is itself a throwback to the past. She urges that we pack the Supreme Court. Again, in the abstract, that's not necessarily a terrible idea, but the devil is in the details. Not to be outdone, would-be President Elizabeth Warren has also urged packing the court, which she assures us would be a means of, quote, "depoliticizing the Supreme Court." Yeah, wrap your mind around that one if you can. Maybe AOC can explain it for us. Well, I could go on, but fortunately we have with us yet another noted Supreme Court analyst whose views may differ slightly from those I've just mentioned. Today's speaker, Miguel Estrada, is well known to the Federalist Society and is no stranger to this podium, having delivered the annual Supreme Court roundup to great acclaim on multiple occasions. Miguel's sterling resume is too filled with remarkable achievements to describe in detail, so I'll mention only a few highlights. After graduating from Columbia University and Harvard Law School, Miguel clerked for Judge Amalia Kearse on the Second Circuit and for Justice Anthony Kennedy. He served as an assistant United States attorney in the Southern District of New York and as an assistant to the Solicitor General in the Bush 41 and Clinton administrations. For the past 2 decades, Miguel has been a highly esteemed and sought-after appellate litigator at Gibson, Dunn, and Crutcher. He's argued 23 cases in the Supreme Court and dozens in the lower appellate courts, and his legal acumen and incisive repartee are widely celebrated. Indeed, Justice Elena Kagan has rightly called Miguel, and I quote, "a towering intellect." Miguel, in turn, has said that Justice Kagan's views on constitutional interpretation are, and I again quote, "as firmly center-left as my own are center-right." All I can say is, if Justice Kagan and Miguel Estrada define the center, I shudder to think what the fringes are like. Notwithstanding these accolades and accomplishments, Miguel is remarkably humble, at least to judge from his oral argument transcripts. To give just one example, when presenting argument in a case involving consecutive versus concurrent criminal sentencing, Miguel used the term consecutivity, prompting Justice Scalia to ask, "Mr. Estrada, is consecutivity a word?" Miguel replied, "I don't know, Justice Scalia, and as a non-native speaker of the language, I feel hesitant to give the court advice on these sorts of matters. Fortunately, I trust he will not be hesitant to advise us on the significant developments of the recently completed term. Please join me in welcoming Miguel Estrada.
Oh, dear Lord, here we are again. Each year, I think I will not make it to the next year because I keep hearing the wall will go up and I will be deported. But, you know, it seems that there are no funds and the emergency is not real, so here I am. So, thank you again for having me. It's an honor, obviously. And clearly it's a slow day in Washington, so I'm grateful. So it's a new term. I can't tell you that it was the most exciting term we've had recently. Despite what Tom said, it was sort of a little bit of a snoozer, but here we are. So we have a new justice, which is sort of a frequent occurrence lately. Justice Kavanaugh, thank goodness. Despite all of the dire predictions of the liberals, that people will die, we're all still here. We have not, descended into a dystopia of Handmaid's Tale. Women still are not in servitude. There are no segregated lunch counters, except when Nancy Pelosi meets with her caucus. But everything is going not quite swimmingly at the Supreme Court, but, the new justice has caused no major waves. He's keeping his head down, which I guess is understandable after the rough confirmation process and all of that. He was out of a number of cases, so the statistics are probably a little bit skewed. On the whole, he voted with a majority in 91% of the 64 cases in which he voted. Again, he was out of a number of cases. This may distress you a little bit and sort of maybe should make us nervous. He voted with Justice Gorsuch about as often as he voted with Justice Kagan and Justice Breyer. Okay. He voted with the chief a lot. He parted ways with the chief a lot too, so there we are. Now, I said last year that the court, with the parting of Justice Kennedy, would likely move somewhat to the right, again, and that's generally true, though I also said that, in contrast to the more liberal members of the court, the members of the conservative bloc, for want of a better label, tend not to vote as a bloc because they all have differences in methodology, and they tend to sort of go to the beat of their own drum, and that has proven itself true in spades this term, where each of the members of the conservative majority, if we want to call it that, voted with the liberals at least one time. Justice Gorsuch 4 times in 5-4 opinions, so he crossed over in 4 cases to give the liberals a 5-4 victory. But each of them crossed over several times. So for those of you who think that we have a 5-4 conservative majority, we actually have, often enough, a 5-4 liberal court. Think about that one. So now the Chief Justice may have not be the justice that voted with the liberals the most often. Obviously, that was Justice Gorsuch. But when he did vote with the liberals, that tended to sting a little. He did it in some of the big cases, and we get to them. But before we get into the nitty-gritty, we do have this tradition that we inherited from Ted Olson, which is we give a prize, right? It is the prize for the individual who exemplifies egregious hypocrisy, crass dealing, and dishonorable behavior. Now, what to do, right? We live in Washington, D.C. It's very hard to narrow down this list because, hey, it is Washington, D.C., and it is sort of a swamp. But we do have a few selection rules that help. One of them is we do not shoot inside the foxhole. So the president is not eligible for you anti-Trumpers as much as he may seem sometimes to really be, bucking to win the award. And so to move to people that actually are eligible, we can start with an honorable mention to the 300 or so no-name wannabes who are running for the presidential nomination on the Democratic ticket. These folks are tripping over each other to open the borders, get rid of private health insurance, provide free college education, and generally destroy the country as we know it. The only question is why they're not being investigated for being in league with the Russians. They're open about it. Now, of course, Tom mentioned Alexandria Ocasio-Cortez, and of course, she has to be a nominee, probably for sins too numerous to list individually. We can start with her statement that the camps for immigrants in the border were concentration camps. This earned her a rebuke from a 93-year-old concentration camp survivor who invited her to visit Auschwitz with him to learn about history, or to learn anything, which she naturally said no to. But my favorite AOC Sally was her draft green plan, the Green New Deal, in which she said was designed to provide economic security to those unwilling to work. Now, in fairness to her, she was probably just playing to the base of her party. Now, of course, again, Tom mentioned Senator Warren of the great state of Massachusetts. I think she displayed the excellent judgment she would bring to the White House by not only taking, but publicizing, mind you, a putative DNA test she took to demonstrate her purported Cherokee ancestry. This DNA test showed that she has such an infinitesimal amount of Native American DNA that it would all disappear if a mosquito bit her. But there it is. But in the end, the title of the award is Egregious Hypocrisy, Crass Dealing, and Dishonorable Behavior. And in the light of all of those considerations, there can only really be one winner. And although we hate to repeat, the winner can only be the same winner as last year, Senator Dianne Feinstein of California. You may recall last year she earned the award for going after now Judge Barrett of the Seventh Circuit for her faith. And I actually had not thought that the good senator could sink any lower, but lo and behold, she does. She is, after all, a ruthless liberal Democrat from California. And so, as you all know, before the confirmation hearings from Judge Kavanaugh, she received a letter accusing Judge Kavanaugh of a sexual assault when he was a teenager. Now, this sort of accusation obviously has to be taken seriously and investigated. The responsible thing would have been for her to go to the chairman of the committee and make sure that this be investigated confidentially to cause minimal damage to all people concerned, both the accuser, Judge Kavanaugh, and everybody who might have relevant information about this. Did she do that or no? She kept it under wraps while she and her staff helped the accuser lawyer up with Clinton retreads, take a polygraph, and sat on this through the hearing, through the closed session, only to make a public announcement calculated to inflict maximum reputational and political damage when she thought the confirmation vote was near. When she got called on this, she pulled the Mr. Magoo Act, that she was too doddering and too confused to really understand what was going on. No, silly me, if she's too old to do her job, she should quit. But in fact, she is a malicious recidivist, for which she has amply and richly deserved the award again this year. And there you have it, Dianne Feinstein of California. Anyway, moving to the statistics, 72 merits cases, 5 summary reversals. There were about 28% of the cases were 5-4. This is slightly higher than last term, but still, within the norm. One case will be re-argued. You sort of scratch your head as to why. The name of the case is Carpenter versus Murphy, and it deals with the hotly incandescent question of whether most of Oklahoma, including the city of Tulsa, is still an Indian reservation. Does anybody care? Anyway, yes, I'm sure people do care. Now, the performance of the circuits appears sort of basically on par with previous years. Only one circuit got, reversed 100% of the time. That was the Seventh Circuit, but they only had one case. If you look at the circuits that actually sort of had cases in any significant number, the winner again is the Ninth Circuit. But 6 is a good guess. The Ninth Circuit had 14 cases in the Supreme Court. They got slammed on 12 of them. The air is different on the West Coast. And so there it is. You will not be surprised to learn that the people who mostly agree with each other are Justices Ginsburg and Sotomayor, and that the justices with the highest amount of disagreement are Justice Thomas with Justice Ginsburg and Sotomayor. So turning to some of the cases on the merits, and try to go quickly through them because Dean otherwise will fire me from this job, we'll start with Madison versus Alabama. Madison versus Alabama is a comeback from a case that we had last year. Mr. Madison is a death penalty inmate. Last year, he was in front of the court because the 11th Circuit gave him habeas corpus. He killed people, okay, but he doesn't remember committing the crime. Now, the 11th Circuit gave him habeas corpus. The Supreme Court summarily reversed the 11th Circuit, saying, well, it doesn't really matter if you recall committing the crime or not. The question is whether you're insane now and whether you really apprehend why the state is killing you now. So back he goes, and he goes into the state courts this time, the state courts of Alabama. I think he's trying to prove that he's really insane. Or that he likes to bet against the House, because he's seeking post-conviction relief from the state courts in Alabama. And so off he goes, and shockingly, the state courts in Alabama find him competent to be executed. And back up the ladder he goes to the Supreme Court again, trying to ride a dissent from the previous case in which, the liberal justices had indicated that the underlying question, whether you can be executed if you don't remember the crime, might be cert-worthy. The court, faced with this question, and with Justice Kennedy still in the court, accepts cert to hear the cert-worthy question, whether you can be executed if you don't remember the crime. Lo and behold, Justice Kennedy leaves. So sad. And so, he switches gears completely, and by the time the new justice is on the court, he doesn't really want to argue, the question he brought to the court. He's arguing about whether the Alabama courts were right to find them competent. So in an opinion by Justice Kagan, the court, surprisingly, sends the case back to the courts in Alabama because she sort of finds that maybe they didn't do this competency analysis entirely correctly. Justice Kavanaugh was not in the case. Chief Justice Roberts crosses over to vote with Justice Kagan to send this case back. If he had not done that, the case would have been 4-4. So one way of looking at that is he was just voting with the liberals to keep, the trains moving and make sure that the case would not have to be re-argued. Justice Alito, in his dissent, pitched a fit, right? Because any business case that came to the court where you pulled that move, where you presented a case and then switched, the argument on the merits would get digged. And he thought this made a mockery of the court's rules, which indeed it did, but it was effective in this case because the chief apparently wanted to keep the trains running. Now, the next death case is Buckley versus Precythe. Now, the inmate in this case is challenging the execution protocol used by the state. Now, the state uses a single drug, pentobarbital, I think, which, the inmate concedes is good enough to kill most other people and animals. But in his case, he has a series of tumors in his neck and in his airway, which he says will blow up during the execution if this drug is administered. And he had an alternative drug that he proposed to be used, where he said that should have been used instead so that he would not be subjected to all this extra pain that the existing protocol would impose. Now, the technical holding of the case, which disagreed with this claim, was that all of these challenges are governed by the existing case law, which was given by the Supreme Court in two cases called Bates versus Rees and Glossop versus Gross. And basically, under these cases, the inmate has to show, A, that there is an alternative method of execution that would significantly lessen, the risk of severe pain, A, and B, that the state just refuses to go with that method for no good penological reason. Now, this guy in this case didn't get past the first one, because his proposed alternative method, which was nitrogen hypoxia, was sort of hypothetical, and the studies that he cited didn't actually stand up, and this method was not in use anywhere, et cetera, et cetera, et cetera. There were, of course, this is a 5-4 vote. The liberals didn't agree that the existing case law necessarily controlled this. All of the usual stuff. Now, there were two things in Justice Gorsuch's majority opinion, apart from the doctrinal analysis that were sort of common sense and actually refreshing. One of them is, hey, this is the death penalty. It ain't supposed to be a picnic. People that were hanged at common law probably didn't enjoy it. That's point one. This is what he says. And so if you think about the Eighth Amendment, what it's meant to do is to keep the state from what he called the superaddition of torturous pain up on top of what the actual execution would necessarily entail in itself. So second, he says, look, all of these people have been beating the death penalty by coming up with all of these endless appeals. And the lower court should carefully police all of these efforts to come up with delay and delay and delay and delay and delay. And that, again, has been a pattern of the death penalty cases in the Supreme Court for the last 3 or 4 decades. And here you have a majority of the court finally telling, the lower courts, you have to watch for that. And we'll see how that's becoming a bone of contention in the Supreme Court in the next section. Justice Sotomayor wrote separately, expressly, to take issue with that, basically to say it doesn't matter when they come up with a good claim, you have to listen to it because it's very important. Now, the next issue, which the court did not consider on the merits, but I think is worth mentioning, is one that came up in a number of stay applications during the term and turned out to be somewhat contentious. And it had to do with whether an inmate who is on the verge of being executed is entitled to have a chaplain of his own faith in the execution chamber. Now, as it happens, many of the states have chaplains that are employees of the state, and in many states, you usually have somebody who's a Christian, or you may have a couple of denominations, but you may not have members of every minority religion. So in the first case, Dunn versus Ray, you had a Muslim inmate who wanted an imam, and the state of Alabama simply said no. The 11th Circuit gave him a stay, finding that the refusal was a probable violation of the Establishment Clause. The Supreme Court vacated the stay 5-4 in a series of very bitter opinions. That was Dunn versus Ray. The main theory of the stay majority was that the inmate had come too late to make this request. There's again the question of delay. Don't play with us this way. Even though the inmate had come basically about a week before the execution. And Dunn versus Ray so embittered, some of the justices that it kept being referenced in merits opinions throughout the term. Now, several weeks later, you had a case out of Texas. That case was Murphy versus Collins. Now, in this case, you had a Buddhist. And Texas, of course, had other chaplains, but did not have a Buddhist. And in this case, the inmate did obtain a stay with Chief Justice Roberts and Justice Kavanaugh switching sides to vote for the liberals to give the person a stay. There was a concurrence by Justice Kavanaugh pointing out that, of course, all the state has to do is give equal treatment, and the state could solve this problem by allowing no one in the execution room and allowing everybody in the observation room, for example, which is what Texas, I think, ended up doing later. Justice Alito, several weeks later, issued a dissent, joined by the other dissenters, who basically took the view that this may be serious questions, but that Murphy was just as late as Dunn, and that he too should have been denied a stay. That prompted Justice Kavanaugh, weeks later, joined by the Chief Justice, to fire yet another concurrence, taking issue with them. So this has been obviously a warm and cuddly term among the conservatives up there. I, on the other hand, am still trying to figure out why Patrick Henry Murphy needs a Buddhist. But I don't know. Our final Eighth Amendment case is Timms versus Indiana, which deals with the excessive fines clause of the Eighth Amendment. Mr. Timms was convicted of dealing dope and stealing. The state wanted to forfeit his $42,000 Land Rover, which he had purchased, get this, with the insurance money he got when his father died. The Hallmark Channel could not make this tearjerkers up. This was more than 4 times the fine available for these crimes under state law. The Indiana Supreme Court thought this was hunky-dory because the excessive fines clause didn't apply to the states. The Supreme Court took the case and unanimously flipped that, holding that under the due process clause of the 14th Amendment, the excessive fines clause is indeed incorporated. So there you have it. Justice Thomas concurred separately to say that under his view, all of these incorporation business should happen under the Privileges and Immunities Clause. Justice Gorsuch concurred separately to say that in his view, it didn't matter a damn hill of beans which clause you invoked. Garza versus Idaho is a Sixth Amendment case, sort of, I think, or at least what Justice Sotomayor understands as the Sixth Amendment. And so we start the story with Roe versus Flores Ortega in the year 2000, 19 years ago, which held that if ineffective assistance of counsel deprives you of an appeal that you otherwise would have pursued, you don't have to show that you would have won the appeal to demonstrate prejudice under Strickland versus Washington. I'll buy that. You don't have to demonstrate something that is sort of imponderable, right? You lost the appeal because your lawyer was incompetent. That's fine. So in Garza, this gem of an individual has several crimes, got 2 separate plea deals with the state. Under the plea deals, he gets a specified sentence. He goes in front of the judge. The judge gives him exactly the sentence that he bargained for. Each of the plea deals says expressly that he waives all his right to take any appeal. Okay, so you would think he walks out of the court, he got exactly what he bargained for. He turns to his lawyer and say, file an appeal. The lawyer, having gone to law school, having some sense of ethics, not having just landed from Mars, or perhaps just not having attended the Yale Law School, sort of turns to him like, what? Because of course, if you understand how this works, if he did that, he would be in breach of the plea agreement, and he might end up in much worse situation than he was at present. So the lawyer does not file the appeal. Predictably, since a lot of these post-conviction remedies are occupational therapy for inmates, there is a post-conviction sort of action filed in which the inmate accuses his lawyer of ineffective assistance of counsel. The state courts take this somewhat reasonable view that there can be no prejudice because he lost an appeal that he had waived by contract, and therefore the Roe case doesn't actually apply here because you had waived your appeal. The case goes to the Supreme Court, where in a 6-3 opinion by Justice Sotomayor, nothing against the Yale Law School here, joined by the Chief Justice and Justice Kavanaugh, she holds that the rule of law Roe applies and there is a presumption of prejudice Even in the case where you waive your appeal by contract, you must presume prejudice and ineffective assistance of counsel where the appeal had been waived because you lost something that you had no right to anyway. Okay. And how could this be? You say, oh, well, says Justice Sotomayor, it's conceivable that the defendant could have thought of something to argue an appeal that was outside of the waiver, like you waive the appeal. What would you have argued? But okay. Or it's also possible that the government might be incompetent and not think of raising, the waiver on appeal. Yeah, pigs could fly, or the government or the president might give up on Twitter. All of these things are possible. The Solicitor General had gone in with an amicus brief saying, well, gee, you should at least require the defendant to show what it is that he would have argued that was conceivably out of the waiver, and so that you can assess what's that, and whether that's something that is, in fact, a good demonstration of prejudice. Justice Sotomayor thought that was unworkable. Justice Thomas predictably dissented with Justice Alito and Gorsuch, and you would think that they would take the reasonable view, which indeed they did. This is actually not surprising given, the court's decision in McCoy versus Louisiana last year. You remember that sort of, the same lineup, if you swap Kavanaugh for Kennedy, basically said that it was sort of ineffective assistance if a lawyer trying to save his client's life basically admitted to everything that the state had him called on and just disputed, the mens rea element of the crime. But here we are. Some of these things don't make sense, and that happens often with the Supreme Court. So we didn't have any big cases dealing with the intersection of the Fourth Amendment and technology this year, thank God, because they tend to screw them up. But we did have the eternal issue of drunk driving. Now, the only thing that we can know at this point, based on the latest installment, Mitchell versus Wisconsin, is that the court's doctrine in this area zigzags more than you when you get behind the wheel after 2 liters of vodka. Now, we start the tale in 1966, Schmerber versus California, in the quaint old days where even Justice Warren could sometimes write sensibly. And so Schmerber deals with a guy who was in an accident because he was so drunk, and the holding of the court is that you can take the guy's blood under the exigent circumstances doctrine because the alcohol blood level is quickly dissipating with time, and by the time you do anything else and get a warrant, the evidence will be gone. Seems to make sense. Fast forward 2013, in the McNeely case, the court said if you got the impression from the Schmerber case that there was exigent circumstances, you were wrong, you have to go get a warrant. The natural dissipation of alcohol in the blood is not itself an exigency. If you usually have time to get a warrant, given that you can get them by phone now, you have to get a warrant. So the dissipation of alcohol is not itself an exigency. So the states tried to get over that by saying, well, if I bust you for drunk driving, I can take the blood as a search incident to the arrest. 3 years later, the court says, nice try, no. And so you would get the impression from that with the advances of technology, the phone and everything else, there's a majority of the court that is firmly on the team of you have to get a warrant, right? Left turn. So we have Mitchell. He's found sort of half naked on a beach. People have called in saying that he was driving drunk, and apparently he had been because he's sort of, barely compos mentis by the time they find him. They give him breathalyzer, is O2222, which is sort of high, I'm told. And then they take him to the station where he quickly passes out, surprisingly. So they take him to the hospital. When they take his blood, and under the aegis of a state law that says that you give implied consent, and if you pass out, you haven't actually, withdrawn it. So the issue that goes to the Supreme Court on a cert question is whether a state statute that basically says that you give implied consent to the taking of your blood by basically taking to the roads is actually consistent with the Fourth Amendment. You get to the Supreme Court, and Justice Alito, who complained bitterly in the death case about, the bait and switch, you may recall, we're very fair here, writes an opinion for a plurality of the court on the doctrine of exigent circumstances. And in it, he holds, for 4 members of the court, that as a rule of law, that, Schmerber is not quite dead, and that there's something to this dissipation of alcohol thing. And so the rule in Schmerber is that dissipation of alcohol plus accident means the cops are busy with something else that occupies their attention, the accident, and that they don't have time to get the warrant, right? The new rule of law that applies not just in this case, but in all similar cases, is dissipation of alcohol plus passed out defendant is an exigency. And so if the guy passes out in the cell, the cops are busy, they have to take him to the hospital, they cannot attend to other duties. And so dissipation of blood plus passed out defendant is a new exigency, you can take his blood. I may be new at this, but I think the people who are really, really drunk tend to pass out. And so I'm not actually sure what's left of McNeely. But there you have it. He wrote for 4 justices, including, surprisingly, his 4th was Justice Breyer. And his 5th, in a separate concurrence, was Justice Thomas, who just would have overruled, the McNeely case flat out. The dissent was 3 liberals plus Justice Gorsuch, who did not address the merits, but very principally said, look, we granted cert on the question of implied consent. We should have addressed that question, and I'm not dealing with this other theory that you've come up with. So that was Mitchell versus Wisconsin. Where are we? Well, we're on drug driving. Fascinating term. Gamble, dual sovereignty. This could have been a big deal if it had gone the other way. The court granted cert on the weighty question whether it should overrule the issue whether if you have 2 prosecutions by the state and the federal government or vice versa, that violates the double jeopardy doctrine. The whole theory here is that you cannot be prosecuted twice for the same offense. Since many, many, many years ago, the court has taken the view that the word offense is a violation of law. Since a violation of law is, the law of a particular sovereign, if you violate the law of 2 different sovereigns, that's not double jeopardy, that's 2 offenses. Seems like open and shut as a matter of textual analysis, and the courts are stuck with that 7-2. Surprisingly, one of the dissenters, apart from Justice Ginsburg, which is not all that surprising, was Justice Gorsuch, who thought that this was sort of unfair. I'm sort of scratching myself and my head over that vote, because the double jeopardy clause was not held to apply to the states until 1969 in Benton versus Maryland. And so for a textualist who has to deal with the offense analysis and an originalist who knows that this didn't even apply to the states until 1969, it's sort of hard for me to see how you come to this conclusion, but there you have it. Next criminal case, Flowers versus Mississippi. Mr. Flowers was accused of killing a number of employees in the furniture shop where he worked days after he was fired. He was tried a whopping 6 times in Winona, Mississippi by the same prosecutor. The first 3 trials were overturned by the Supreme Court of Mississippi for Batson violations and other prosecutorial misconduct. Trials 4 and 5 were hung juries. 6th was the charm. He was convicted and sentenced to death. The Supreme Court took an interest in the case and found in an opinion by Justice Kavanaugh, joined by the 4 liberal members of the court, plus the Chief Justice and Justice Alito, that the state had engaged in Batson violations that warranted, the overturning of the conviction. This is mostly a fact-bound application of the Batson case, so it's not all that interesting. And Justice Kavanaugh wrote a very narrow opinion. Justice Alito wrote separately to point out that this was an exceptional case, et cetera, et cetera. Those of you who pay attention to the court will know that it is extraordinarily difficult, since his appointment to the Supreme Court, that is Justice Alito's, to find a non-unanimous case in which Justice Alito has voted for a criminal defendant. So if Justice Alito thought this was a Batson violation, you can probably take it to the bank. U.S. versus Davis is yet another case dealing with the residual clause, definition of the crime of violence. This is yet in another statute per Gorsuch 5-4. Once again, the court found this clause vague. Nothing to see here other than Justice Kavanaugh took issue with that. You may recall that in Justice Scalia's last term, he had held the Armed Career Criminal Statute void for vagueness on this ground, and there have been a number of cases basically with the identical language that have been held void for vagueness since, Sessions versus DiMaia last term, and now Davis. Finally, the last criminal case, which is not all that interesting except for the practical consequences, is a case coming out of the 11th Circuit called Rehaif versus the United States. If you are an illegal alien with a gun, you probably should be running for Congress as a Democrat. But in this case, maybe you have to be a bartender first. But in this case, it is a federal crime, and the question was whether you have to know both about the gun and about your status as an illegal, which scarcely, I don't know how you would fail to know that. But in any event, the lower courts had almost unanimously held that you had to know about the gun, but not about your status. The Supreme Court disagreed with that, and that's going to have a lot of practical consequences because there were about over 6,000 of these cases last year alone, which probably gives you more of an insight into the immigration problem in this country than anything else. And there's going to be a lot of habeas corpus 2255 applications following this case, about which the dissenters, led by Justice Alito and Justice Thomas, actually complained bitterly. We're going to touch briefly on a couple of civil rights cases, mostly for the entertainment value. There is a case called Nieves versus Bartlett, which raised the weighty question whether you can have a 1983 claim for a violation of your First Amendment rights, basically for talking back to the cops, when the cops basically take you into custody and they had probable cause to bust you. And so this comes out of something that I guess can only happen in Alaska, or I hope can only happen in Alaska, called the Arctic Man Festival, where apparently people go to get really drunk and engage in really extreme sports, and hoped to meet, the daughter of the governor, maybe, I have no idea. But apparently, it attracts a number of people who are not supposed to be there, namely minors, who are not supposed to be doing the extreme sports, and certainly not the drinking. So Trooper T, Trooper W was there, and was trying to interview a minor about whether he had been drinking. The plaintiff, Mr. Bartlett, tried to intervene to keep the cop from talking to the minor, like stop bothering the kid, whatever. This went downhill. There is video. Nieves, who's the supervisor of the trooper, sort of arrived. The two subdued the guy. He was charged with disorderly conduct and other, related crimes you would sort of expect. This being the sort of social offense, it was all dropped later. This being, the West Coast and the Ninth Circuit, it was obviously a 1983 lawsuit seeking millions of dollars. And, the theory of this was that the true reason for the arrest was that the defendant had had an altercation with the trooper earlier in which, the defendant had, refused to talk to the trooper and basically gave him the hand. This is like a major constitutional issue, I'm sure. So the Ninth Circuit holds that this person has stated a First Amendment claim, and that even though there was probable cause for the arrest, that's not a defense for the First Amendment claim. They have to defend it. The Supreme Court takes it. And the question here is whether the case is controlled by an earlier case called Hartman. And now, in Hartman, the Supreme Court had held that probable cause for arrest defeats this sort of action when you sue a prosecutor or a judge for malicious prosecution, the violation of the First Amendment. Now, the wrinkle here, right, is that the judge and the prosecutor have absolute immunity. And you could think of that sort of action as just an end run over the absolute immunity that you would have for the prosecution or the judicial function. And the question was whether you would basically apply something that is a common law, Fourth Amendment law of the arrest to the First Amendment issue. The court ultimately held that yes, probable cause is a defense to the First Amendment claim, except since this is an opinion by the Chief Justice, where you show that this is not really the type of offense that the cops really would have arrested you for, et cetera, et cetera. So it's a little bit wiggly. There was a separate opinion by Justice Thomas, which would have ruled for the cops, without the qualification. Justice Gorsuch concurred only in part and dissented in part. He worried that, the court was confusing doctrines and should basically do more to vindicate, the libertarian aspect of this and the separateness of the First Amendment claim. And Justice Ginsburg and Sotomayor dissented separately to urge, the application of the Mount Healthy framework to all of this. We're going to touch base quickly on some business cases. Obviously, the biggie was Apple versus Pepper. For those of you who know antitrust law, if you are bringing some sort of price-fixing claim or conspiracy claim, you can usually just sue direct. You have to be a direct purchaser. You cannot sue, remote parties. Now, the Apple App Store is set up so that you sort of ostensibly buy from Apple, but in fact, it's sort of an agency sort of issue where the app makers put their products on the Apple shop, and it's they who are selling, with Apple taking a 30% commission. Now, the theory of the suit was that Apple's 30% was a markup, that it was some sort of price fixing, and that Apple was sort of a monopolist. And the question was whether the true defendants on this should have been the app makers, and whether this was a violation of the Illinois BRIC formula. The district court, I think, sort of agreed with Apple. The Ninth Circuit, an opinion by Willie Fletcher, sort of agreed with the plaintiffs, surprisingly. And the Supreme Court, somewhat surprisingly, in an opinion by Justice Kavanaugh, who sided with the liberals on this, disagreed with Apple and held that since as a formal matter, the plaintiffs were dealing with Apple, it actually didn't matter how the internal arrangement actually was structured. There was a very strong dissent by Justice Gorsuch and the other conservatives. It is possible that this may be sort of a flash in the pan, and that can be all sort of dealt with by, rearranging how the contracts are all structured. But it was sort of interesting to see, again, the conservatives sort of on two sides of this. There is a fascinating civil procedure exam in Home Depot versus Jackson, which basically has to do with the weighty issue whether if you're a counterclaim defendant, you can actually remove. Here there's a state claim. You get added as a defendant later. You try to remove. The question is whether you can. The answer is no. This is a case with Justice Thomas crossed over to join with the liberals. And he basically said there was a case from 1941, Shamrock Oil versus Sheets, that seem to indicate that if you're a counterclaim defendant who's added later, you cannot exercise rights under the removal statute. Congress has not changed it, and that has been the rule. Congress can always change it. That was Justice Thomas' view. If you're not a defendant on the original complaint, you can remove. In Lamps Plus versus Varela, we came back to the eternal question of arbitration and the Ninth Circuit's eternal efforts to evade and defeat the Supreme Court's ruling on this area. This was one of those class action issues. Mr. Varela wanted to get out of his arbitration issues. What the Ninth Circuit tried to do is to rely on a state law rule that basically said that ambiguities in contract are construed against the drafter. This was an opinion 2-1. Judges Reinhardt and Wardlaw against, I think, Judge Fernandez, even though it was a PC. Judge Reinhardt famously said that the Supreme Court can't catch them all. Somebody else once said that when he died, they would have to bury him face down because he was bound to be flipped at least once after he was gone. And here you have it. The Supreme Court 5-4 basically disagreed with the Ninth Circuit on this one and held that under Stolt-Nielsen, Concepcion, and all those cases, the rule of state law that the Ninth Circuit purported to apply was preempted. The liberals and the court disagreed so vehemently with this that each of them wrote a separate lengthy dissent, which sadly I don't have time to do a dramatic reading from, but would bring tears to your eyes. the whole thing about Judge Reinhardt brings to mind another Ninth Circuit special, who has to be sort of only in the Ninth Circuit. There was the Jovino case versus Rizzo last term, an en banc opinion, mind you, from the Ninth Circuit, authored by Judge Reinhardt after he was dead, which went to the Supreme Court, which had no trouble overturning it by pointing out that the Constitution does allow judges to serve during good behavior, which you can construe as life tenure, but not for eternity. And so you cannot vote while you're dead, even if in Cook County that is sometimes not always the rule. Another Ninth Circuit special was a case called Nutraceutical versus Lambert. Now, the rules basically say you have to file a 23F petition on a class cert appeal in X days. The Ninth Circuit thought, well, X days could mean Y days. This is subject to equitable tolling. The Supreme Court, 9-zip by Justice Sotomayor said, no, it doesn't mean that. X days is X days. There were issues as to why if there is, what do we do if there's a real emergency? Justice Alito said, every lawyer always says he has a real emergency. You could have an invasion from Mars, he said, at oral argument. But no, X days is X days. Frank versus Gauss was likely to be an important case having to do with the doctrine of Cypre, whether you can basically have a class action in which the class members get nothing and everything goes to charities and whatever. The court didn't get to it, as important as it was, because it accepted the Solicitor General's suggestion to look carefully at the possible lack of standing and send the court back for that issue. There were another couple of business cases of minor import that I won't get into the details because you probably stone me. There were several Indian law cases that, again, I will skip for the same reason. I will only say that Justice Gorsuch loves Indians. You might think that this makes sense. He's coming from the West, except that Justice O'Connor always voted against the Indians, and she was also from the West. And so you can't get anything from that. Now, turning to something actually interesting, we turn to the First Amendment. Our first case is an opinion by Justice Kavanaugh in a fascinating case called Manhattan Community Access versus Halleck. The question here is if the People's City of New York has a private corporation run public access channels, are those channels a public forum? Somebody wants to put some crapola TV show on these channels. They got told no, they sue, and they say, well, I have a First Amendment right to put my, program on this public access channel. The Second Circuit buys this. The Supreme Court 5-4 says, no, this is not a public forum, it's a private corporation. A, it's a cable company, so it's hard to see them as the government. B, the court sort of saved, the question of what would happen if the city were actually running, but it would still be a cable company. It would be the city running something that is owned by a private cable company still. But in any event, doesn't seem to have any major implications. Turning to something that actually does, or is at least mildly entertaining, we are back to the Lanham Act. Now, you may recall Mattel versus Stam 2 years ago dealt with the very entertaining disparagement clause of the Lanham Act, which basically said you could not register a trademark if it disparaged persons or institutions living or dead, et cetera, et cetera. Now, the Supreme Court basically overturned that under the First Amendment because it was content-based and viewpoint-based. In that case, the government had made a valiant effort to say that trademarks were government speech. Didn't work out. Justice Alito basically made fun of them because the government had registered things such as pull your panties down, and that might be government speech in the Clinton administration, but it wouldn't work always. So ultimately, the disparagement clause went down, and this year, we had the son of Tam, a related clause of the Lanham Act that makes it, that prohibits the registration of immoral or scandalous marks. Now, Mr. Brunetti has a mark that was turned down for registration, is for clothing, and well, this is going to be on cable, so I guess it's allowed. The brand of the mark is fucked. Now, he insists that the brand is actually called FUCT, though the majority opinion by Justice Kagan pointed out, quote, you may read it differently. Or, she said, as the equivalent of the past participle form of a well-known form of profanity. In any event, all 9 justices agreed that the immoral part of this is equally unconstitutional, in an opinion by Justice Kagan, for a 6-3 majority. They sort of had more issues with the scandalous part, and whether it could be narrowly construed to apply to something and serve the government's interest and morals, et cetera, et cetera. The prudes sort of standing for public, morality were sort of an odd sort of assortment of the Chief Justice, Breyer, and Justice Sotomayor. That I don't understand. Moving to an even more interesting and important case in the First Amendment, we have the American Legion versus the American Humanist Association, and this deals with the religion clause. This is the Bladenberg Cross, a monument which is a cross that is 32 foot tall. It's a Latin cross that was erected in 1925 to honor the dead in World War I in Prince George's County, Maryland. Over the years, it has stood, and ultimately it became part of a public park. It's sort of upheld, just for the upkeep, et cetera, et cetera. And so there's always somebody who likes to rock, the boat, and who's easily offended. And so naturally they brought suit. And the Fourth Circuit sort of concluded that this was a violation of the Establishment Clause in a series of opinions that would just make you wonder how these people got through the Senate. Some of the proposed remedies were like chop up the arms or, okay. Honestly, of all things. So you go to the Supreme Court, and the Supreme Court overturns, the Fourth Circuit in an opinion by Justice Alito. And it's 7-2. So, even the Supreme Court, that often thinks these issues are contentious, didn't think that this was that difficult. So the big issue here is whether the Lemon test, which you may recall, Justice Scalia once described as a ghoul from a late-night horror movie, was going to finally be fully and finally interred, but not quite. Justice Alito, in his majority opinion, which was joined by the Chief Justice Breyer, Kagan, and Kavanaugh, basically went out and said bad things about the Lemon test, and ultimately basically said that it had been criticized a lot and he wasn't going to apply it, but ultimately basically came up with a rule for really old monuments and basically said, this was sort of okay. And Justice Breyer and Justice Kagan sort of wrote a separate opinion saying, well, there's no single test, so we don't need to get into any of this. There are many, many considerations, which is part of the song he's been singing all along. Justice Kavanaugh wrote separately to say, Lemon is dead, 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 dead. Let's have the funeral right now. I'll call the funeral service. Justice Kagan wrote separately to say, it's alive, it's alive, it's alive. Justice Thomas said he will overrule Lemon, and then none of this should apply to the states anyway. And Justice Gorsuch sort of also wrote separately to say nasty things about Lemon. Justice Ginsburg and Justice Sotomayor were deeply offended by this cross and dissented. It's a symbol of Christianity. We have partisan gerrymanders. For like a long, long, long time, we've been playing footsie with Justice Kennedy on this issue. Whether it was the 14th Amendment, it was the First Amendment, the theory that Justice Kennedy kept sort of trying to noodle with was whether if you suffered because you're co-religionists in your party were not getting elected in a different part of the state, whether you had a free association claim under the First Amendment, which was a theory that, if you thought about it, really had no limits, because then you could sue about people who share your party affiliation in a different state, right? Because I really care about the Republicans in California because they're a dying breed. I should go sue there. And so it's sort of a crazy theory that didn't match with any cognizable standing theory. But the poor man kept trying and trying and trying, and Justice Kagan kept sort of egging him on and egging him on. And meanwhile, you had these three-judge district courts coming up with arcane, mathematical models trying to figure out what the ideal map should look like. And it was all sort of entirely opportunistic, right? The Republicans got sued in the South, and the Democrats got sued in Maryland, and it all depended whose ox was getting gored. Finally, in Rucho versus Common Cause, the court has mercifully put an end to this, and an opinion by the Chief Justice, 5-4. The Chief Justice ruled that this is just a political question. It is impossible for the court to devise politically manageable standards for how much politics is too much politics in coming up with political maps, and that this is just not a question that's meet for judicial judgment. So therefore, courts should just stay out of this. We're done with this. There was a separate sort of case dealing with apportionment, a Virginia House of Delegates versus Bethune-Hill that was not quite as important. This was an alleged racial gerrymandering that went off on a question of standing. The issue was basically whether half of the House of Delegates had standing to continue with the litigation after the Attorney General turned tail and left. It was interesting, mostly for the combination of justices. The justices who thought there was no standing were Ginsburg, Thomas, Sotomayor, Kagan, and Gorsuch. And the justices who thought there was standing was Alito, the Chief, Breyer, and Kavanaugh. It was sort of an interesting back and forth on how much of an interest half of the legislature had to continue with the case. There was an immigration case called Niels versus Priap, which is only interesting because it presented the sure-worthy question whether the Ninth Circuit can read. The answer is no, but someone alarmingly, it appears that a majority of the Supreme Court can't either. In a 5-4 ruling, the Supreme Court sort of ruled that a statute that says that if you're a certain type of alien, you're not eligible for bond after you get released by state custody, even if you get set at large sort of by accident and you are sort of at large for several years, you still have to be taken into custody, that it does mean that you're not eligible for bail. The Ninth Circuit has thought otherwise, and so did for liberal justices, because, hey, you made a life for yourself. This is not so nice. Anyway, government won that one. We have Franchise Tax Board versus Hyatt. One of those fascinating cases dealing with federalism. The issue is whether you can sue a state in the courts of another state. In Nevada versus Hall, the court said yes. In this case, the court overruled Nevada versus Hall. It's a fascinating fight about how you evade California state taxes, which are indeed oppressive. Mostly is a junior varsity fight about what stare decisis means in constitutional adjudication, and it's all about Roe versus Wade, and oh my God, what am I going to do now that these people have 5 votes? So it's all about that. Next case has to do with the Takings Clause of the Fifth Amendment, and again, is the overruling of a Harry Blackmun special from 1985 called Williamson County. In Williamson County, Harry Blackmun basically, for a court, said that if you want to have a takings claim, you have to go to the state courts first to say if they will give you just compensation. Now, it was sort of a catch-22 because after you go to the state courts, then under the full faith and credit statute, when you go to federal court, you are collaterally estopped. So you basically lost your takings claim. In this court, an opinion by the Chief Justice, the court overruled Williamson County. Again, this time Justice Kagan and everybody else is really upset about how we are, too quickly getting rid of stare decisis because we have other cases that we really, really care about. I won't tell you which, but it rhymes with woe. We have Tennessee Wine, Spirits, and versus Blair. This has to do, this is an interesting case for the conservative court because it all has to do with the 21st Amendment, which maybe is sort of a relic, but it really puts the conservatives a little bit to the test. Back in the 19th century, where you had all of the temperance movements, all of the states tried to keep booze out. And they ran against the Supreme Court that basically said Commerce Clause, Commerce Clause, Commerce Clause, right? So Congress passed a couple of statutes, Wilson Act and the Webb Canyon Act, that basically tried to help the states, and the Supreme Court found ways to basically get around those and basically stop the states from trying to regulate booze, even with the congressional imprimatur. So the states basically had it, and we got the 18th Amendment, prohibition. That didn't work out so well, and so then we got the 21st Amendment getting rid of prohibition. But the deal was, this Section 2 of the 21st Amendment, that says the states get to do whatever the heck they want with liquor, you know. From 1933 on, until the 1950s, 60s, every Supreme Court case that dealt with this basically said the 21st Amendment is intended to be an exception to the Commerce Clause. You get out of the Commerce Clause. That's the whole point of it. There is an opinion 9-0 by Justice Brandeis in 1933, just after the passage of the 21st Amendment, that basically has the same claim as this case, that deals with it, that concludes with the line, to accept the claim here would involve not a construction of the amendment, but a rewriting of it. Now, usually the conservatives take the view that the people who lived at the time of the enactment of the relevant provision actually knew what it was about, and usually you take the view that Justice Brandeis, was not an idiot. And sure, I mean, there are sort of exceptions. The Alien and Sedition Act is probably not the best measure of the First Amendment. But what is surprising is that starting in 1984 and then in 2005 and now in this case, you had like 3 cases in which purportedly conservative members of the Supreme Court are so drawn by the free market that they have just discovered that all of the early cases in the 21st Amendment, they were not so right, and the Commerce Clause actually still trumps the 21st Amendment because the states are not allowed to engage in protectionism. So the ruling in this case is that a state that has a residency requirement for people who sell liquor engage in a violation of the 21st Amendment if they don't link them enough to the police interest in temperance, etc. Now, the state can say, gee, we want you to live in the state because then you see if you're actually selling too much liquor and your own children get run over by the drunk drivers, etc. And Justice Alito, for the court, sort of accepted that these were sort of good interests in temperance, but they were sort of attenuated. So it's an interesting sort of shift for the court to say, well, the Commerce Clause still trumps the 21st Amendment. You have to come up with good interests that are not protectionist, that are tied to your interest in regulating liquor. And we're not going to tell you exactly what those are going to be. One of the big cases in the term that sort of fizzled is Gundy. Gundy, everybody thought, was going to deal with the reemergence of the delegation doctrine, but it didn't turn out that way. Now, the Sex Offenders Registration Act, which sort of in the news these days, sort of basically says that if you are a sex offender now, you're convicted today, there is like a reticulator and detailed statute as to what you have to do. You have to register, etc. But when SORNA was passed, there were a lot of people who were already sex offenders who had been convicted, that is, other than Bill Clinton. And all the statute says as to them is that the Attorney General will figure out what to do with them. And so you would think that that is an immense delegation without any guiding principle, without any detail. And pretty much every Attorney General since then has basically taken different views as to what they can do. And so this was the ideal case to sort of bring a non-delegation claim. It sort of fizzled at the Supreme Court. Justice Kavanaugh was not participating. And then in an opinion by Justice Kagan, she discovered, based on the purpose of the statute and the legislative history, that what SORNA actually means is that the Attorney General doesn't have any discretion. He must register as soon as he can, everybody. Now, it would be hard to get that out of any language anywhere in the statute. Justice Alito did not join the opinion, but gave the vote needed for the court, and he simply wrote a concurrence saying, I can't say that given the non-standards the court has had for the last 70 years that this doesn't pass muster. if the court were willing to reconsider this doctrine, I'd be game. And so it's sort of anticlimactic because I don't think we're ever going to have a statute in which, the wolf comes as this wolf. But he could have said that and set this case for, re-argument with Justice Kavanaugh being able to actually take part. So the whole thing is sort of a fizzle and a mystery. But there it is. Similar issue with the Auer case. Everybody thought it was going to be a big sort of issue as to whether we were going to get rid of our deference as a prelude to taking a bite out of Chevron. Yet another victory for Justice Kagan, joined by the Chief Justice this time. And her view is, no, it's not that meaningful, our deference, because you basically exhaust the toolkit on every tool of construction, and then there's very little for agencies to do this. It's not that meaningful. Now, the Chief Justice wrote separately to say, well, she's right, and actually this doesn't mean that much, and Justice Gorsuch, who's pitching a fit in dissent about how we should get rid of this, and Justice Kagan are not that far apart. And both the Chief Justice and Justice Kavanaugh sort of wrote separately to say that what they were doing with Auer was not necessarily indicative of what they might do with Chevron, but we'll see. And so I'm sure they're all waiting for the big case in the term, which is how we're closing the census. What to say? So the Secretary of Commerce, Wilbur Ross, who every time I hear his name, I think of Mr. Ed for some reason. Some of you are just not old enough. So he decided early on that he wanted the census question. For those of you who don't know, most civilized countries actually do have a similar question on their censuses. The United Nations, that hotbed of right-wing extremism, actually recommends that countries ask this question in their censuses because, of course, it's not crazy to know how many citizens you have in your own damn country. I mean, it is a census. And for those of you who don't keep up with the news, this was a question that was asked in some form for most of the life of our country, of everybody until basically the 1950s, and for from some section of the population since then in the shorter form of the questionnaire. But in any event, and so he decides to do this. But as so often the case with some of the administration's initiatives, it was sort of a little bit ham-handedly executed. And so he gets on the horn and starts calling everybody to try to gin up a request from them to actually put this in the census, instead of sort of saying, gee whiz, I'm the damn Secretary of Commerce. I'm going to order these jackasses to put the thing on the census, because he wants ammo to fight the Census Bureau because all of the bureaucrats don't want to do it. And so ultimately, he gets a taker by getting the Civil Rights Division to do this and calling the Attorney General. He writes a memo that sort of explains that he did this because the Justice Department wanted it. There's all suits by everybody that basically says that this will, depress, the minority vote, et cetera, et cetera. I'm not understanding. If you're a citizen, you're entitled to vote. And so I don't follow the chain of reasoning that would deter somebody from actually, anyway. In any event, so there's a lawsuit in the Southern District of New York and elsewhere. Judge Furman, an Obama appointee who clerked for Justice Souter, but who's otherwise a very good judge, basically takes debate and orders all sorts of massive discovery. The government plays ball, and even though you're supposed to solve these things based on the administrative record, there are like 12,000 pages of a truckload that is dumped. There's all these emails that show that Wilbur was actually calling all and sundry trying to set this up. The Southern District basically holds that this is illegal on every conceivable ground, pretext, a violation of the APA, a violation of the enumeration clause of the Constitution, etc. There is an appeal noted to the Second Circuit because that's necessary before you can seek cert before judgment. For those of you who don't recall Marbury versus Madison, you can't appeal, directly. The court gets cert. The court does give them cert before judgment, and an opinion by Chief Justice Roberts the court sends the case back, basically agreeing with the challengers. It's a fascinating opinion because mostly the court agrees with the administration. The court agrees on the Constitution, that the enumeration clause basically doesn't bar this sort of question, because of course you can ask things that are not strictly a count, since throughout history you've asked all sorts of things. And the court sort of agrees that this is not a violation of the APA, because even though all the lefties in the Census Bureau kept trying to fight the secretary, he gave a very reasoned explanation as to why he didn't agree with them, and he actually went through sort of a very reasoned way as to why he wanted to do this. And so, the court sort of agrees that, this is not a violation of the Administrative Procedure Act regular way. But just as in the Obamacare sort of decision, where you were going, okay, Commerce Clause check, woo, left turn. Then we get to the end of the opinion where it goes, oh, but there's a pretext here. What he said about the DOJ doesn't actually match what he really thought. We don't actually really know what he really thought. Because all of this truckload of documents show that he was looking to do this from the beginning, and it was not really the DOJ that caused him to do this. Now, there are two things that are interesting about this. One of his first holdings is that it was improper for Judge Furman to require the administration to produce all of this discovery. Second point is, but now that we have it, we're going to use it. And so, I don't know what the lesson is for willful district court judges, not that there are any, right? Which is that if you can jam, the administration in power and force them to sort of produce stuff that are beyond the administrative record, one of the fundamental tenets of administrative law, which is that review is confined to the administrative record, is basically gone, and that you can go in a fishing expedition on the theory that, for all you know, the administration, whoever the incumbent administration may be acting in bad faith. Anyway, it's sort of an interesting and bizarre opinion at that level, because yes, you did wrong, but I'll take it. I kept thinking of that scene in Casablanca with Claude Rains. I'm shocked, there's gambling here. You're winning, sir. In any event, so we have some interesting cases last year. I'll just mention quickly. The cross-border shooting in Hernandez versus Mesa is back. We have a Second Amendment case on whether you can take your gun out of the city of New York, of course, to a shooting range. We have the Puerto Rico case on the Appointments Clause on the Financial Oversight Board, and we have the DACA case. We also will have, once again, one of these amendments that sort of cut off aid to religion in the Espinosa case next year. So it promises to be a far more interesting case than this year, and maybe, the conservatives would find time to talk to each other and learn to like each other a little bit more. But that's all I have today. Sure. I'll send no questions to Tom Hunger. Maybe there aren't any questions. Going once, going twice. Oh, there's somebody over there.
Good afternoon. I'm Darlene Jackson with the National Black Republican Council. And for today, I prepared a...
Could you speak up,
Can
please?
you hear me now? Good,
Yes.
okay. Today, I prepared a writing called Roe v. Wade, It's Time for Shade, about 8 pages long. And it goes into the transcripts of the re-argument in 1972 and so forth. My question to you, because you kind of tapped on a little bit Roe versus Wade, but do you think that the GOP, for example, should have a real strong strategy going into the storm coming, Roe v. Wade? It's coming.
Well, I don't know. I don't give political advice to two candidates. I think, people run on what they run on, and they have to pick, people don't choose their voter. So you choose where you run, and you figure out how you can get elected. I mean, I really have no idea.
I'm really speaking to the exact U.S. Supreme Court in terms of how they will probably rule if it comes up for an overturn.
Well,
because
I don't know.
We got the fetal heartbeat bill now, because prior to, during the road time, the issue was viability of the fetus. And the court ruled on that, even though it had no medical writings and no medical recognizable writings to address viability. Now we have the fetal heartbeat bill.
Well, look,
15 states have already signed it and by the governor, so it's a storm coming. So how's the Supreme Court going to? Okay.
Yeah, well, I understand that, but there are a number of laws that may be passed that may bring some of these issues in front of the Supreme Court. The court will consider them when there are actually cases. You have to have cases that bring these issues to the Supreme Court, and they may come up in front of the Supreme Court. They may not.
Mm-hmm.
Whether people run for office or don't run for office is less relevant than having cases that raise these issues. If and when the issues get to the Supreme Court, I do not know that the current composition of the Supreme Court is such that the court would overrule that case. I do not necessarily think that the Chief Justice would necessarily overrule Roe versus Wade. And it may be that if you are somebody who believes that case should be overruled, you would be better positioned to have the issue reach the court with 2 more appointments by a president who believes the case should be overruled than now.
Richard Wolf. Oh, okay.
Miguel, we've seen with the case out of New York on the Second Amendment coming up, we've seen the New York folks trying to moot that case out. Any predictions on what the court will do in light of those efforts to moot the case, voluntary cessation, things like that?
Well, I don't know that. Well, voluntary cessation as a mootness doctrine requires that the case is capable of repetition, yet evading review to the same parties. And so if the government repeals the ordinance and the same plaintiff who wants to engage in the conduct is able to make a convincing case that this is a ruse to evade review, it may be that the court will be able to say that that the case is not moot. But I think it would be relatively rare for the Supreme Court to say that a governmental entity is engaged in deceitful behavior, even Bill Blasio, to escape, review of a constitutional issue. Okay, thank you.
Thank you. Thank you so much, Miguel, for a wonderful survey of a term which some of us thought was interesting, even if you thought it.
We've seen better.
But anyway, thank you very much. We have a long tradition here, usually for giving our speaker a copy of the Federalist Papers. But the Federalist Papers, are wonderful, but there may be a limit to the number of copies you can use. Now, there's also a limit to the number of these that you should use, but the limit's not quite so small. So, Miguel.
Thank you.
Thank you all for coming.
Very nice meeting you.
Good. I never really got a chance.
Yeah, right. Hey, good to see you, dude. Long time no see. How are you? Yeah, I know that guy. What's up? How's it going? All right, all right. So I assume you're practicing law? Very cool.